Seeing that there had been no changes to the initiative from its form that was submitted back in April, the City Attorney's Office has reviewed, considered, and concluded that the initiative is invalid for 4 reasons. Those are set forth in the staff report and in the clerk's certification, but for our record, I would reflect that the petition, if adopted, would impermissibly interfere with the legislative authority of the City Council, which is therefore contrary to Washington state law. The petition, if adopted, would impermissibly interfere with the administrative authority of the City Council, which is also therefore contrary to Washington state law. The petition, if adopted, would impermissibly interfere with the implementation of the statewide law, specifically the Washington Growth Management Act. And finally, the petition, if adopted, would violate the requirements of Section 10.01 of the Vancouver City Charter that initiated ordinances must not embrace more than one subject. Now, I know you heard comments from, among others, the attorney representing the Save Our Vancouver Streets initiative. And respectfully, we are engaged in a legal process that is by its nature designed to have attorneys representing conflicting views. And so we are by our nature in an adversarial system of government.
Situations like this are where, as an ICMA member, their code of ethics acts as a North Star for me on how I have to advise the City Council. My responsibility is to steward the process under the Charter, review the relevant facts of the case, and assure that the recommendation that comes to you is as free from a predetermined bias or outcome as we can. As part of that, I lean on the advice of our legal department and have to weigh the potential risks for the city. That ethical requirement is relevant because sometimes I have to deliver news that is not what people want to hear, which is tough when you have supporters that are clearly so invested and passionate about an issue. When the city clerk's office received the signed petitions, they forwarded them on to the Clark County auditor to review whether the petition contained the number of required signatures. After that, it came back to our city clerk's office where we also verified the signatures, but have to do an additional test to see if the subject matter is within the bounds of what can be lawfully submitted for public vote under the initiative process. Now, this includes a review of if the proposed initiative meets the standard for single topic, whether it exceeds the limits of what the Constitution allows, and whether it unlawfully interferes with the powers and authority that are granted to the City Council. And ultimately, in the opinion of our City Attorney's Office, this is where the petition fails to meet several of those legal standards that would allow it to be placed in the ballot. Adhering to my ethical standards means that I must advise you not to proceed with action on the petition. If I advised otherwise, it would be asking the City Council to proceed with an action that the best available information tells me is illegal. And that would
The City Council has 3 options on what to do with the initiative tonight. One is to pass the initiative. The second is to reject the initiative and allow it to go to the ballot. The third is to pass an alternative measure in a different form. What it does not have is the power to reject the initiative and prevent it from going to the ballot, to prevent it from being submitted to the registered voters at the next election. Section 10.8 of the city charter makes it clear that the proposed ordinance shall, that language is mandatory, be submitted to the voters at the next general election. The staff analysis does cite to cases in which parties have challenged invalid initiatives, but all of those are initiated in court, not from the city council or not as a result of the city attorney. I would respectfully suggest that this council follow the city charter and allow this matter to proceed to a vote. If it fails, then there is no harm. If it passes, then whatever legal arguments are appropriate can be raised in court.
The considered opinion of the Vancouver City Attorney's Office, however, is that the process that we find ourselves in tonight never reaches Section 10.8 of the City Charter. Instead, we're really under Section 10.04, which is that first review by the city clerk evaluating whether or not there is legal sufficiency and whether there are an adequate number of signatures. While there are adequate signatures, for the reasons I mentioned, there is not legal sufficiency to this ballot petition. Therefore, our recommendation is that you take no action tonight.
All right, it is the consensus of the Vancouver City Council that no action be taken on this initiative. And that concludes the public hearing for this evening.